Greetings to you, members of the Agora legis community. Welcome back to our platform where we discuss legal principles, make them easy to understand for everybody. Today we are continuing with contract law 1, and we shall be looking at the topic of consideration in contract law. We shall see what do we need to know under this topic, basically the definition, types of consideration, and lastly the rules governing consideration. So without further indulgence, I'm Counsel Ben, and let's jump right in. By definition, according to Section 1 of the Contract Act, Cap 284, a consideration is defined as a right, interest, profit, or benefit to accruing to one party of the contract or forbearance, or it can be also the detriment, the loss, or the responsibility given or suffered or undertaken by the other party of the contract. So basically, members, here we are looking at the fact that one party is gaining something and one party is losing something. That is what we call basically consideration. If I'm to enter into a contract with my media team there over there and say that, well, you will be mounting my videos and editing them. In that instance, what is their consideration there? The consideration is the money that I'm paying to the studio, but uh, my consideration is the service that they're rendering to me. It is a detriment that they are doing to move under all this sun to come and record the video. So basically, that is it. What do you gain under the contract? What the other party lose under the contract for your benefit? That is what we call consideration. The very same definition was given in the case of Curie versus Misa. But also, I would urge you to go and look at the case of Barney versus Guy, in which the court defined also consideration as the loss or inconvenience suffered by one party upon the request of the other. Members, after defining and understanding the concept of consideration, we shall now look at the types of consideration. And basically, we have two main types of consideration. Firstly, the executed consideration, and secondly, the executory consideration. Executed consideration means that uh, the consideration has been carried out at the time of the contract. All right. So here, for example, in the case of Khalil versus Carbolic Smokeball Company, Mrs. Khalil had already carried out consideration that was expected by the Carbolic Smokeball Company. So executed consideration means that at the time of the contract, the consideration is carried out. If it is in a contract of sale, the price was paid at the time of the contract. Secondly, members, we have executory consideration as the second type of consideration. And here we are looking at the fact that the consideration is to be carried out at a future time after the contract has been made. As compared to the executed consideration, the consideration was done at the time of the contract. But here, it is agreed in the contract that, oh, so and so is to pay the amount of money for goods sold maybe 2 months later after, or 2 weeks later after delivery of the goods. So here in this contract, in this particular case, we are looking at the fact that consideration is to be carried out at a future time. And this is the main difference between both types. Executed consideration, has been carried out at the time of the contract. Secondly, executory consideration to be carried out at a future time. Third point of our discussion, we are going to look at the rules governing consideration. After looking at the definition, looking at the types, we are going to dive into the rules that govern the principles on consideration in contract law. So the first one already states that consideration must not be passed. What does it mean here? It means that consideration should not have been carried out before the contract was made. For example, in the case of Remark Adol, the repairings made on the house before the contract was made or before the agreement was made could not amount to a valid consideration since the action was already passed before the contract was made. So consideration should not be passed. You should not do something, then you enter into an agreement that what I did was your consideration, now you're bound to do this for me. No, the other party has to have a valid consideration that is not passed. So do not confuse this with executed consideration. Executed consideration is a consideration carried out at the time of the contract. Just after entering into the contract, one party fulfills already his part of the contract. That is what we call executed, as opposed to these rules that says that consideration should not be passed. Means that consideration has to be carried out at a time given after the contract is made, but not before. Secondly, as per the rules governing consideration, we have the fact that consideration must be sufficient but needs not to be adequate. What does it mean here? Sufficiency means that the person is satisfied with what is given to him as consideration as part of the contract. In third position, members, we have the fact that uh, consideration has to move from the promisee to the promisor. What does it mean here? It means that one cannot claim consideration from another party if himself has not fulfilled his part of the contract. For example, in the case of Twedo vs. Atkinson, in this case, fathers of a young couple entered into an agreement that they will be depositing some amount of money for the couple, but before completing his part of the contract, one of the fathers died. And when the other sued the executor for the money, the court held that he could not sue since himself had not yet fulfilled his part of the contract. So this is reflected in the Latin maxim that he who seeks equity must do equity. Fourthly, members, performance of an existing duty does not amount to a valid consideration. Once someone is under a given duty, under a given obligation, he cannot claim that outside the contract, he cannot claim that
to be a valid consideration.
Number five, performance of an existing contractual duty does not amount to a valid consideration. What does it mean? If in a given contract, a party has a duty, let's say, to inform the other about something for the other party to have the possibility of carrying out their duty under the contract, that information cannot amount to valid consideration. Why? Because it's already an existing contractual duty. So a party cannot claim that he has carried out consideration in case it is only an existing contractual duty. Number six, we have the fact that part payment of a debt does not amount to valid consideration. It is only until a party has carried out full payment of that debt that he will claim that he has already fulfilled his consideration. Lastly, members, we have the fact that consideration has to be real and lawful. An unlawful consideration already renders the contract void ab initio. I urge you to go and look at Section 18 of the Contract Act, Cap 284, which provides for lawful consideration and object. And they say that a consideration is lawful except when it's involving a fraud, it's involving harming someone and someone's property. So it's explained clearly and widely what amounts to a valid, legal, and lawful consideration. So members, that is it for today. We have seen the definition of a consideration, we have seen the types of consideration, and we have looked at the rules governing consideration. I hope you have grasped it, and I hope you like, subscribe, and share. Thank you for watching the video, and see you in the next one. It's always Agora Legis with Council Ben. See you.